Hello, I'm joined with these three wonderful speakers. We will be discussing their article on algorithmic governance and computational antitrust. Marcela Mattiuzzo is a PhD candidate at the University of Sao Paulo and partner in the practice areas of competition law and data protection at VMCA, a boutique Brazilian law firm. Dr. Nicolas Petit is Joint Chair in Competition Law at the University Institute's Department of Law and at the Robert Schuman Center for Advanced Studies. Dr. Beatriz Botero Arcila is an Assistant Professor of Law in the Digital Information Economy at Sciences Po Law School and Faculty Associate at the Berkman Klein Center for Internet and Society at Harvard University. Please welcome our speakers. I'd like to start off with Marcelo.
Hi, everyone. Can you hear me? You can. Okay, that's great. So first of all, I would like to thank for the invitation, both to write the paper back last year, and also for the opportunity to discuss it further today with Nicola and Beatriz. I think that's excellent. And actually for a lot of the computational antitrust discussions is what we need in order to, try to take the conversation forward. So just very briefly trying to cover what our paper, I co-wrote that paper with Henrique Machado, what the paper intended to cover. So the main objective of our paper was to bring some of the algorithmic governance discussion that is, a well-established discussion that has many authors that are engaged with it, and apply it to computational antitrust. So what exactly would be the, convergence of those two areas, and what would result of that convergence, if anything? So in order to do that, what we've aimed at accomplishing was basically designing a bit of a roadmap of how those things could intertwine. And I think, as we've been discussing throughout the conference so far, the relevance of this debate has only grown since we wrote the paper, right? So I believe we're all aware that the OECD recently had a roundtable focused on the use of data screening technology for antitrust investigations. And it's precisely this kind of situation that the paper is interested in addressing. Because when we talk about algorithmic governance, of course, we can approach it from a private sector perspective. But what our paper aims at doing is looking at it from the perspective of the agency, right? So what if an agency wants to implement those tools? What are the particular concerns that arise from that scenario, right? And they're mostly tied to concerns about due process, right? So agencies in general, because they're a public body, have a different burden when they're making decisions generally. They have to justify those decisions. They have to show why they reached certain results in order as well but of course, for clarity and for, safety on the side of private sector, but also for the public, right? So it's very important for that to happen in order for everyone to understand what's going on and for people to be able to contest and appeal decisions, right? So the use of those tools by antitrust agencies raises these different concerns that, though of course, as I mentioned, are present in the private sector discussion, are perhaps less prominent in the private sector discussion. And what we tried at least to do is to provide some dichotomies throughout the paper that would help antitrust authorities look for situations in which this concern that we're talking about is more prominent, and situations in which the concern is perhaps a little less prominent, and particularly in identifying what is different from those circumstances that we're talking about that entails different, potentially at least, different solutions, right? So the first thing we do is, of course, like provide a general overview of what has been going on in the computational antitrust discussion and how authorities have been incorporating those tools in its decision-making processes. And then we move on to like presenting a little bit more of the algorithmic governance discussion as well, just to provide a broader overview of what are the debates that have been going on within that field, so that we can later reach the part where I think we should perhaps focus on a little bit more today, which is how do these things combine, right? What we do is that basically we try to put forth three particular dichotomies, as I mentioned, that would help agencies in assessing what exactly is the problem they're dealing with and how it could be, potentially solved within that scenario. And I think the main thing that we should focus on here is that obviously these dichotomies that we present, they're all in sort of a scale of gray, right? So it's easy, they're helpful in that they provide methodological clearance, but it's really hard to say like, okay, precisely this is happening or precisely that is happening, and there's no in between, right? So as we will see, for computational antitrust and for use of algorithmic tools overall, it's not so easy to pinpoint exactly whether we're on the one side of the dichotomy or the other. But the proposals that we have is to differentiate first between what we call pure automation and AI/machine learning technologies. And why do we think that's relevant? For a very simple reason. Whenever we're talking about automation, like traditional automation, in theory, what we have is lines of code, right? That someone, or most of the time someone's, right, several people have written down to make an algorithmic system work. So all of those lines of code are there. And like at the limit, if we provide transparency for this algorithm, we should be able to assess everything that's going on there, right? So if an agency is using a system such as that, we are in one universe. Whereas if we're using artificial intelligence in general, most of the time, the traditional transparency tools will not be enough, right? And it comes into play the idea of explainability that comes from the algorithmic governance literature, in which just providing transparency of the algorithm itself will not necessarily help us understand what the algorithm is doing. Of course, for people that are not programmers, it will always be harder, but even for programmers, simply knowing what the code for an AI algorithm is will not necessarily help understand what is going on, what is the decision-making process that is happening within that system, right? So that's the first distinction that we think would be helpful. The second is a distinction between assistance versus decision-making. And again, as I mentioned, we're in a scale of gray here. So what we're focusing on is trying to see what the algorithm you designed helps you with, right? Does it help you in the final decision-making process? Does it help you in a step of the decision-making process? If it's a step, what step is that? Is there human oversight of that decision, or the human oversight is very limited? So, I mean, a simple example would be if you program an algorithm that is in charge of like counting deadlines, that's one thing. But if you're programming an algorithm to determine what the penalty for a given violation should be, that's entirely a different thing, right? And last but not least, what we call a difference between concrete adjudication and ex-ante measures is also a category that we're using. So the goal here is to think of the relevance of clarifying what will be automated and how before taking measures. And ideally, possibly defining accountable departments within an antitrust authority to respond to concerns that may arise from the public. So I think this is something that generally antitrust authorities are pretty familiar with, right? So you explain how process is going to happen before you actually make it happen. So that's something that in our view should not be so hard to implement. And we also mentioned like the use of benchmarking tools to implement any system, any AI or automated system that antitrust authorities want to use and wish to use might be helpful as well in that sense, right? So testing it out, keeping logs, and overall doing what software engineers are very used to do could be helpful in implementing those tools as well. So I think that's mainly the overview of the paper. Of course, there's a lot more there, but I think it would be more interesting and helpful for us to hear from Nicola and from Beatrice on their views as well, and for us to discuss a little bit. So again, thank you very much, and looking forward to the discussion.
Thank you. So yes, I'd like to continue with Dr. Petit's discussion of the paper.
Well, thanks a lot to everyone here, and to Thibaut for the invitation, as well as his team, of course. And I'm glad that I could learn from reading Marcella's paper and Erika Arthur's paper today. So I'm very happy to be here. I'm gonna essentially try to ask a few questions about the paper in my remarks, and maybe end up with some more personal comments, but I would really like this to be more question-driven than comments-driven. Okay, so I understand the paper is studying the issues arising from the implementation of computational techniques in support of antitrust enforcement. And I understand the argument in the paper that these new techniques of antitrust enforcement raise serious governance problems to which we should pay attention. And in a way, the paper echoes discussions which are arising in other fields of the law, of legal scholarship, about the introduction of AI-enabled technologies and instruments in a lot of areas of the legal system. So this is my understanding of the paper, and I think the paper does a great job at pointing out and discussing the various governance challenges raised by computational techniques in the antitrust field. I also think the paper is very well written, so I would certainly advise people who couldn't read the paper to rush to download the paper because it's very well written and organized. Okay, so one of the considerations, I'm going to start with my first question. So one of the considerations in the paper that seems to justify, according to the authors, certain governance railguards in relation to the use of antitrust, of AI and computational techniques in antitrust, is the risk of violation of due process. Okay. So if you use an AI system in support of an antitrust investigation, remediation, and decision, you might be concerned that certain safeguards that the non-AI or non-computational procedure embeds are not protected here. And so there's this principle of equivalence between the legal safeguards, railguards that exist today, and the safeguards that should apply in a computational version of the existing environment. Okay, I wonder to what extent this equivalence holds in all areas and stages involved in an antitrust investigation. So I would like to understand why the assumption seems to be made that the same procedural due process safeguards that apply in the, say, physical antitrust world should apply in the computational world. There might be some cases in which the need for, so there are two derivations to the question. One is in the physical antitrust, if I may call it this way, in the classical antitrust, the non-computational world of antitrust enforcement, there are many stages in procedures in which due process is really not in discussion. The agency is given full discretion, or the court is given full discretion. In these cases, I think the discussion about safeguards for computational antitrust is not deserved. And so I think that I would like to know in the, more in more detail from the paper, which are the critical areas in which due process deserve to be protected from the use of computational techniques, right? The second thing is, if we move to so the second derivation is, if we move to a fully computational antitrust system in which both defendants and agencies and courts and plaintiffs can rely on these techniques, so the game becomes a game in which both set of actors to an antitrust investigation are computationally assisted, do we still need such a strict concern for due process, right? Do we really still need to talk about this? That the arguments of the defendant would not be given equal consideration or unbiased consideration, or wouldn't the AI system of the defendant, for instance, be able to detect violations and talk immediately with the other system and address these concerns? So, do we see a sort of equilibration of the equality of arms by reciprocal reliance on computational techniques on one side of the table and the other side of the table? So these are the two derivations of my question. So the first one is about the equivalence. The second one is about the equilibration of the level playing field between defendants and plaintiffs. Okay, I have a second question. So the second question is related to the language and discussion that we have in the European Union. Marcella, I know you're not from the European Union, but I'm going to explain and give a little bit of context. So we have a proposal for regulation here from the European Union, and one of the key of AI systems, and one of the key proposal is to define certain practices, certain AI practices which are unacceptable. Okay, so these systems which implement these practices are not allowed in the European Union. They cannot be used by the private sector. They cannot be used by administration. Okay, so I wonder whether reasoning in terms of unacceptable practices, you would see some areas of antitrust enforcement which should be red line against the use of AI techniques or computational techniques. Like, I don't know, maybe, setting a fine or ordering a divestiture. Are there certain areas where this should be off the table? Okay, and how do you go about picking up these areas? Okay, my third question, I hope I won't be too long, and so I'm looking at Glenn, so he tells me how I'm doing on time.
You're still doing fine on time. Yeah.
Thank you very much. Okay, so my third question is about it's more of a question about the Loomis case, which you talk about in your paper. So the Loomis case is this case in which a person that had been convicted by courts and was trying to get, I think, a reduction in the sanction. There's this possibility over a period of time to apply for a commutation or reduction in the penalty. I'm not really too familiar with the facts, but in the broad lines are something like this, and then the question becomes for the examining authority to decide whether there is a risk of recidivism, in which case you're not going to grant parole or commutation of the penalty. And so the Loomis case was about this, and an AI system had been, an automation system had been used to establish the risk of recidivism, and Marcela and Akash discuss this in the paper. I recall that in the Loomis case, one of the courts had discussed the kinds of procedural frameworks and governance railroads that could be applied to accept or not an algorithmic instruments in the courtroom, right? And there was a set of criterion. So do you think these criterions, they would apply equally in antitrust, or are there specificities in an antitrust context that would require something different when we think about it, about these procedural safeguards? So that was my third question. And okay, maybe my last remark or question / remark relates essentially to the first one, but I just want to give you a little bit my thinking about this. So when I look at antitrust law, what do I see? I see a system of rules and principles, which is essentially a gigantic inference machine. Okay, and so because the facts are imperfect, you give an agency or a court the ability to draw inferences about the existence of an anti-competitive result. So, for instance, in the law, in the Sherman Act and in the EU Treaty, for instance, the laws that I know better, Section 1 and Section 2, they say cartels are bad and forbidden. And this is an inference that if you have a cartel, and if you have coordination between independent agents in a market, you're going to end up with a bad outcome, right? So the law has this inference embedded in its text, right? And then if you take Section 2, we say monopolization is bad, and because we infer that a monopoly is not a good thing. So then the case law came up on top of this to say, well, look, wait a little. We can only draw this inference if we make other inferences. Okay, so one inference we have to do to establish that a monopoly is bad is to establish the market share and the entry barriers that exist on the market. Okay, so the courts came up with these new concepts which say, okay, for the inference to be valid, you need to go through other types of observations which will allow an inference. Okay, and then how do you know the market share? You need to define the market. You need to define the market, relevant market depth. It's another inference machine that we have in the system. So you're going to say, okay, if we screen for substitutability, then we can infer that the products are in the same market. And so the law of antitrust in text and application is essentially a huge inference machine. Okay, and so in your paper you talk about computational systems, and you explain very rightly that these systems are essentially extremely good inference machines, right? So we could potentially replace our entire if you know, assume we have a gigantic great machine that that has performance that we don't have today. This machine could potentially indeed replace this old set of very clunky and brittle case law and text law inferences where there's lots of scope for error, right? Okay, so again, if you look at this way, in the potential replacement by a computational system of all these sets of inferences, if we did this, what would this mean? What would antitrust law look like? Would we need an antitrust law in the first place? Could we just have observation of outcomes, like prices go up in the economy and the machine says, oh, it's bad, let's just remove this? Could we have an antitrust law that works on outcomes more than on processes, like condemning business conduct or transactions like mergers? So that's my more philosophical question. So Marcela, thanks for the paper. It was amazing.
Thank you for those questions. Next, we will have Dr. Beatriz Botero Arcila discuss her thoughts on the paper.
Thank you, Glenn and Theo and everyone for organizing. And Marcela, thank you for this paper. I actually totally agree with Nicolas. Like it's really, really good. And I think one of the interesting contributions that it does is that it's a very nice and neat summary of the algorithmic governance conversation. Like I don't think I'd seen such a nice synthesis somewhere. And I'm sure it's going to be my to-go article to sort of map these issues, and I'll put it on my syllabus and all of that. So actually, I agree. If anyone hasn't read it, it's actually really, really good and highly recommended. And it's interesting because I come from the other side of the table, right? So I guess here I am the algorithmic governance person, and Nicolas is like the antitrust person. So one of the things that I really liked was that it's a very practical way to operationalize and create a framework that actually goes into the practice of a bunch of the things that we talk about when we're talking about AI. One of the perhaps things the AI field suffers from is that we talk of AI as if it were like this big ghost, but no one really knows what we're talking about. And I was listening to a podcast the other day that said that we talk about AI until we know what it is, and then we call it an algorithm. So no one says the Spotify AI or the Facebook AI, we say the Spotify algorithm or the AI algorithm. And I think this paper is also a very nice contribution in the direction of like bringing this down to actual things that are not only predictive policing. So I'm very interested in the questions that Nicolas asked. I had a very similar one, you'll see, but I'm also interested in turning this more into a conversation and less in my comments. So I had two main questions. One of them is that I am into the algorithmic governance field, but I'm also a data governance question. And because that's my hammer, everything looks like a nail to me. So one of my questions is actually that I see you do like this very nice work of operationalizing the framework, as I was saying, but I'm curious if you see, so a big part of the risks that we talk about when we talk about risks associated with AI are also risks associated with data governance, are risks associated to enhance surveillance, and then that's actually an interesting link to Nicolas' question. Like, is that really a risk? What is do we need due process? Maybe enhanced surveillance is what we want, right? Maybe we really just don't want people doing things that are fishy. So I have a question about how this traces into data governance broadly, and in particular, where did you see personal data risks emerging? So I was earlier in a conversation where we were talking about this AI system for analyzing judicial decisions, and it doesn't replace lawyers, fear not, but it actually allows lawyers to connect decisions to each other, and you could like go to one decision and see these are the precedents that relate, and it's very good at systematizing. And one of the interesting conversations, apparently this is litigation ongoing under the ECHR, is there a privacy risk there? All of a sudden you have like first instance decisions that no one would have read ever, that contain details of the personal life of people, right? Like you might have been robbed, you might have been attacked, you might have been a suspect of a crime of some sort. But this was data that was in theory public, but opaque by nature. It was in paper, it was hidden somewhere in the files of a court. And all of a sudden, because you plug in an AI system that is now turning it into a startup, this information that was public but opaque by nature is now becoming, I don't know, it's out there, very much within reach. I wonder if something like that exists in antitrust. Maybe it's not personal data, but I don't know, trade secrecy, patents related, I don't know, sensitive business information, or maybe personal data. I don't know, like I'm curious to see if you think there's an aspect of that that we might be stressing about. And another thing that I observed in your paper, which is a feature, but I think an interesting exercise, is that I feel like you're trying to do this tension where you go with the like hype and then you try to like rein it back. So when is it automation and when isn't? Like when are you really doing something that's totally different, and when are you just operationalizing something that would have been done? When is it assisting a decision that's just a decision that we're typically taking? But I would like to hear more of you about the conversation that Thibaut was having with someone from the DOJ right before, and then that actually links maybe also to Nicolas's questions about how do you think this actually changes the work of the agency, and whether it's not by nature a move towards predictability. And even if we know that we can't predict the future, the push is strong for believing that we can. And what are the risks there? What are the potential? And if there are risks, whether you think this also requires changing a little bit the rules of antitrust enforcement. Just to finish and to maybe clarify that last question, one of the things that I often wonder about when I'm doing like AI governance in the like suspect fields, which is always like predictive policing, or in the migration context is always very controversial, is that a bunch of the times the human thing happening is very bad, but it's totally legal. Like it's totally legal to, or it's part of what the police is supposed to do, right? If you are someone that doesn't have your paperwork in order, you're very rarely protected by law. And the system is geared towards, the question is, now we put like steroids on the system, and this is happening in mass. And so I wonder, should we just change the system? Do we need to change our migratory rules to retain the power of the government more, for example? Are things that were normal in the law enforcement process because it was less automated and so opaque by nature, automated, and we need to rein back? I wonder if you see a transformation of the actual antitrust agencies happening, and whether that should lead to some like more administrative maybe reform eventually. But again, thank you so much for writing this, and I look forward to hearing from you.
Thank you both so much for the questions, for reading the paper carefully, and for the very nice comments about it. I'm happy to hear that it's actually like concise, because that was one of the main challenges of bringing enough of both the computational antitrust and the algorithmic governance discussion to the piece. So there's a lot of questions, a lot of them kind of intertwine. So I'll probably go back and forth, and like feel free to ask again if you think it's not sufficiently clarified. But I think that starting by the first point on whether, like, what is the real due process concern here, and should we have a due process concern throughout the whole decision making of an antitrust agency, right? I think the point is, we for sure do not, and we for sure do not have that right now in a lot of the decision making that happens in antitrust agencies today without any computational tools whatsoever. I think that is important because, in fact, we would have to look at where actually due process is relevant, so that we could implement tools that guarantee due process is happening where it's relevant. Precisely so that we don't fall into two problematic categories, which is like trying to make everything due processy, when in fact that's not even what happens today. So, I mean, why are we trying to do that if it's not really how it should work, right? But of course, there are instances in which like due process should be possible and it's necessary. And it's what, to some extent validates and guarantees that decision making by public authorities is, at all something that should exist. So I think you're right in that it's tricky to not, fall into the tail of, okay, so the whole process of decision making has to change just because we're using a computational tool. And I'm going to link that to the last question a little bit, because I think those things are also intertwined, which is a lot like, what does the job of the agency look like if we're using computational tools, right? And I think that speaks back to what exactly changes and what are the problems that algorithmic systems in general and AI systems in particular actually bring about. Because it's very important for us to understand that some of the problems that maybe we are now giving more prominence to because of AI are not AI problems, right? So they are just policy issues that we have to address and that have always been hard to address. And it's important for us to devise good tools for them, to not mix them up with like, oh, this is a new AI problem. It's not. It's just a problem. It was always there and we had to solve it before. We have to solve it now. Maybe we have more, because of the system, perhaps we even have more clarity about that problem actually existing, right? But of course, there in answering more specifically whether like there are specific conduct, for instance, in antitrust that because of an AI, of the deployment of an AI system, perhaps change in nature. I think that's the discussion that has been happening with, for instance, parallel pricing, right? So parallel pricing was always perceived as something that, this is not a cartel. Companies are just arriving to the same prices because of like natural market reasons. And that's not illegal. Fine, but what if everybody is now using systems that allow for parallel pricing to be much more frequent than it was before? Should that change the nature of the conduct itself? Yes or no? And if yes, what exactly is the standard that we're going to use to, evaluate that conduct? And all of the discussions about intention and like, is the objective of the system reaching parallel prices? Is the objective of the system just, maximizing output and so forth and so on? So I think there are areas in which we could have discussions that the use of AI has perhaps, or will perhaps in the future, change the nature of the legality of a practice, for instance. Of course, it's not, there's a lot of debate, right, today about whether that should happen to parallel pricing in particular. But I think we can see the debate happening. But again, it's important for us to know when we're dealing with a new problem, typically algorithmic system problem, and when we're just dealing with a problem that was always there and we just had to deal with it before, we will have to deal with it now as well. And then perhaps jumping to the second question, to Nicola's second question, which was, should due process be as relevant as it is today if we're speaking of like both the private actors and the public agent having access to sort of like a level playing field of computational antitrust, in which perhaps that is not such a complicated process issue anymore? I think my answer to that question is I'm not sure, which is a bad answer. But I think maybe not, but I fear we're far from that reality enough that it's hard for me to conceive of a reality in which due process would not be so particularly cumbersome or so particularly relevant, though I think it is theoretically possible. So in theory, I would say like for sure, and maybe that's something that we could address in a different way from what we do today. And maybe that concern would be, less relevant in the future. But I fear that we're a little bit far off from that right now. So I wouldn't commit to saying like for sure this will not. I mean, we will come to develop so far as to turn that theoretical possibility into a reality, right? But and then trying to mix both the question about whether they're like the use of the logic of, you know, the risk logic, which is, in my understanding at least, but do please correct me if I'm wrong, how the European Union is trying to approach the use of AI, right? So it's saying, okay, these categories here are something that we're red flagging and we're redlining and saying, it's too much risk. We don't want you to use that. We don't want you to use AI systems at all for this applications. I think that I think it's interesting that the next thing that you says is, okay, and then there are these categories for which, you know, you can use AI here, you can use the system here, but we're applying a higher level of scrutiny and, you know, a lot more responsibility if that is something that you want to do. I think it's possible to apply that same logic perhaps to antitrust and to use of AI tools by antitrust agencies. As you said yourself, Nicola, so maybe like fines. Actually, I don't know if generally fines, like the amount of pecuniary fines is something that I probably would be fine handling to an AI system. I think it would probably, if the system was good enough, be less biased than just, you know, a judge, because of, you know, you can program it a little bit better for it to be less biased. But maybe like the sufficiency of other forms of sanction, which are deployed by several antitrust authorities throughout the world, right? So the divestiture, as you mentioned, could be something, but it could also go like a lot further than that, right? So that could be a potential place in which you would say, okay, I don't want an AI system choosing that. I think like for some, you know, for some thresholds of theory of harm, we could also say, okay, you can use the AI system here, but you would necessarily have to have some form of like human review or something of the sort. I think application of that logic might work with antitrust agencies as well, if that's something that we wanted to do, and if we thought that system was interesting. It's good to note that we are probably having a report tomorrow in Brazil regarding the new proposed bill for AI regulation. So let's see if we're moving towards that same direction. And if there's something specific about the use of AI systems by agencies, like generally public administration, that signals that Brazil is moving towards what the EU is also defining, which at this point is what people bet on, but we don't know for sure. And
sorry, I don't mean to interrupt. I want to make sure we have time for the questions in the chat. So I'd like to start off with some questions that we prepared before as well. So what do you think are the 3 core principles that every antitrust agency should keep in mind when implementing algorithmic governance?
Okay, I think the first one that I would say is just know what you're applying the system to. Like, what is the goal of your system? What is it being applied to? Like, so having that clarity is super important. The other one, which is like what antitrust agencies tend to do overall, is just clarity to the public. And by that, I do not mean like, oh, do everything open source. Not necessarily, but what I mean is like communicate clearly what you're doing so that people understand it and are able to like criticize it, or just generally say, okay, I don't really understand what you're doing here. Could you please explain it a little bit better? And the third one, I think, would be finding your bottlenecks and perhaps trying to deploy AI and algorithmic systems in general, where you really do not have human resources available, and trying to identify where it really would help you the most with the work that you have to do. And by that I mean, not necessarily it's like decision making in concrete cases. It might be something like way more basic and administrative, which might sound a little underwhelming. But having worked in an antitrust authority before, sometimes that really consumes a lot of time and energy from the team, and could be really, really relevant in order for final decision making to take place.
All right, thank you. This is next questions to Dr. Nicolas Petit. Would you add any other principles beyond those just mentioned?
Look, I'm not writing a paper on this topic, and so I didn't have a chance to think about additional principles. I think Marcela got it right with this first sample of principles. I think transparency is a must with all these technologies. This is probably, to me, the most important principle that any agency or court should uphold and implement. So be very transparent in what techniques are used, what data sets are relied upon, in what context they're used, why. So we should maintain a very high level of transparency. And, I think it's important because there is, in antitrust practice, a very strong bias against transparency, because one of the conditions for the effectiveness of agency investigation is the ability to operate under some darkness, right? Investigate markets and search markets. So I think the tension is here. Up until a certain stage in an antitrust investigation, that is a statement of objection or a second request, or the agency must have the ability to operate under certain screens which allow it to investigate the firm. Sometimes the firm doesn't know it. Sometimes the firm, at some point, the firms must know it, but the public might not know about it. So I think the tension here is, as we want to rely more on these techniques to improve the efficiency of the antitrust system and of competition and welfare in market economies, you need to increase transparency in how the agency works, but this doesn't necessarily conforms with the culture of agencies and the conventional method of antitrust investigation.
All right, thank you. Next, Dr. Beatriz Botero Arcila. We have a question. You have recently worked on data markets. Do you see a role for antitrust agencies in fostering these markets?
Yeah, thank you for that question. It's a tricky one, and I might know who asked it. I think there is a role for antitrust agencies in participating in shaping what data markets are necessarily. I don't know if fostering is the word. Like, I think the way I see it, so in my world, in the world of data governance, data markets is actually rather something controversial. There's a rather big concern on what it means to commodify information, especially when it's about personal data that happens to a wider extent in the US than it happens in the EU, because in the EU we have the GDPR, but still there are data markets in the EU. And there's of course the question of whether in an environment that it has a lot of privacy regulations, whether you're actually creating too much friction on the movement of data in what is a digital information economy. That's more like the European question. And I think that given that question, this is certainly somewhere where antitrust agencies need to intervene. Or it would be useful eventually for them to participate in looking at what are good practices of the market or not from an antitrust perspective, right? Like there might be groups or companies for sure that have a lot of power by the sheer data that they govern and have access to and control and how they move it in the market. And then have other entities that are more vulnerable because of that power. I don't know if it's the role of antitrust agencies actually to foster those markets. I think the market is happening, and maybe the role of the antitrust agency is to make sure the market is fair at more levels than just privacy rights, like who has access, who's controlling information, how do we open it up without creating other risks, and so on. That might be something where we will see antitrust agencies intervening. They have started doing so. That was a big part of mergers concerning Meta. And I think we're just going to continue seeing more of that for sure.
Thank you for that answer. Marcelo, we have some more questions for you from the chat. First one, but why can't we just encourage guardrails in the development of those algorithms? Shouldn't we just require algorithms to output their confidence and relative weightings to different factors? We can always outlaw complete black boxes.
I think we can. I think like it's challenging to develop systems that have that, you know, embedded and built in, but something that is, you know, doable. I think a little bit of the discussion, of the technical discussion, trying to be brief here, is that a lot of authors point out that the more, like the easier it is to explain a system and to ensure full explainability, the less good the system is at reaching the right results. So that's a really big tension, right? Because you want it to be fully explainable to a certain extent, especially if you're dealing with a public authority. But at the same time, if you do that, that might make it, you know, less reliable in terms of the results. So I think, like, generally that's what we should aim for. We should build in guardrails and care about that when we're building the system, but there might be some specific technical tensions in doing that.
Great, thank you. Next question. We see the courts, at least in the jurisdiction I am working in, Romania, struggling with accepting economic-based evidence in antitrust cases. Starting from this, what can be done to increase the court's preparedness/openness to discuss and accept AI-based evidence? And related to this, how can we ensure there is a level playing field, at least within the EU internal market, when the national competition authorities and courts from the member states are not equally prepared and equipped to use or accept AI-based evidence?
I mean, that's a bunch of questions. And I'm not sure I have a good answer to, like, maybe Nicolau or Beatrice have, you know, want to have a go at how to ensure the level playing field. I think it's just generally challenging. But my feeling is that in order for courts to better accept the use of AI, and then maybe running back to one of the questions that Nicolau had and that I didn't really answer, it really depends on, first, a broader discussion about what an AI system can do and what it should do and what we as a society are going to accept that it does. So if we, and those are all very complicated questions that we will not answer today. I mean, I do not intend to answer any of them right now, right? But because there's a lot of discussion, philosophical discussion about should we, you know, to what extent should we allow these systems to go? And once I think we have a better, like, societal understanding of that, it naturally becomes easier for a judge or anyone really to accept the use of the system, because then, you know, this discussion has been carried out. But my feeling is that it will be very hard for it to be well accepted, unless by people that are already prone to accept it, unless we carry out this discussion previously, because the morality of the discussion, the level of acceptance of the use will always be questioned to some extent. If not on initial decision, it will be questioned on appeal and so forth and so on. So unfortunately, I think it's a very complicated way to ensure that that happens at a sufficient level, be it in the EU or anywhere else.
Yes, Dr. Botero.
No, I just want to totally endorse what Marcela said. Like, I think there's a lot of this, and you said this earlier very nicely. I think there's a lot of this that aren't like AI governance questions per se, but policy questions. But then also, one of the questions of the level playing field is, and that's more a philosophical or policy question that has less to do with the mechanics, is how are we going to govern this new form of massive power, right? Like, what are the new checks and balances? And it comes both when you're thinking about how do you govern or create checks on the agency, but also on the parties who are using tools, collecting data, doing things like that. And those are the questions. Like, I don't think it's only about the particular algorithm in a particular instance, but actually it goes way back, as Marcela was saying. So totally agree.
All right, thank you. The next question is directed towards Dr. Petit. I'm sure that AI systems are able to apply ex-ante rules pre-designed by a lawyer, but my question is, if an AI system create new legal rules or modify the ex-ante rules for better? So between those two options, ex-ante or modify for better.
Okay, so if this it's a question about the capability of AI to either improve enforcement of the law by ex-ante application or improvements of the rules by rule making, right?
Yeah.
Okay, so using it, yeah, okay, so using AI to enforce more efficiently or using AI to design updated rules in antitrust. Look, I don't know. I mean, it's just a wild and difficult question to answer. Will an AI system write a better antitrust law than the one we have today? I don't know. What would be the benchmark to assess that? Will an AI system help enforcement by applying more ex-ante? Yeah, maybe. I mean, if you say AI systems are good prediction machines and they're pretty good at predicting antitrust crime, then we should expect indeed that the AI systems will allow us to intervene more efficiently into markets. But the rule-making thing is just, for me, very hard to answer. The thing, I mean, one thing I want to say about this is we're not going to fool ourselves. I mean, we have two very different systems of antitrust text. When you look at the US and the EU, the rules are just not phrased the same. Section 1, Article 101, Section 2, Article 102, these rules in text are not the same, and both converge to the same system. So I don't, and these rules are very abstract and very, very narrow and not very lengthy. So, where are the gains in terms of rule making? I'm not sure.
We have 2 minutes left, if you want to add to that.
Like, super brief, like I agree with Nicolas. I also think the question of what is a rule is a political rule. I mean, it's a political question. It's not a technical question. And whether the AI can improve something or not, that we give legal weight to as lawyers or policymakers or so on. It's very much a political choice. Eventually, though, I'm sure the system can be better at translating, maybe at predicting the operationalization. But the legal power, actually, and authority of the system depends entirely on policymakers, and that changes a little bit the question and the consequence.
All right. If each of you could give 30-second conclusion, if you feel like it, before we go.
Sure. Yeah, I'm gonna conclude to like an additional addition to that last question, which is like, at the end of the day, all of the discussion that we're having here does not bypass the overall discussion about like, what is the role of antitrust and where should it lead, right? So what is a better rule? What is a better system? That depends on what we're optimizing for, right? And that discussion is still something that we'll have to deal with. So I think algorithmic systems and the discussion about algorithmic governance is very important, but it has to be understood within that context. And again, thank you everyone for discussing. Thank you, especially Nicola and Beatrice for having the opportunity to be with you.
All right, thank you all. It was great hearing all of your answers and to discuss this wonderful paper.